Companies Act, Section 200, Central Government or Company to fix limit with regard to remuneration. Section 200 of the Companies Act, 2013 provides guidelines for the fixation of remuneration for key personnel in situations where a company either has inadequate profits or no profits at all. This section is relevant primarily in cases where the company seeks approval for appointments or remuneration as per the provisions of Section 196, dealing with appointment and terms of remuneration for directors, and Section 197, relating to the remuneration payable to directors in certain circumstances. It enables the company to set limits on the remuneration of its key personnel based on various factors that reflect the company's financial health and the qualifications and experience of the individual concerned. This provision ensures that while remuneration is fixed in cases of inadequate or no profits, the company takes into account a range of factors that would allow for a reasonable and fair remuneration structure. 1. Scope of Section 200. Remuneration in the absence of adequate profits. Section 200 provides flexibility to companies in deciding the remuneration limits when they face situations of insufficient profits or even no profits. The section acknowledges that companies may still need to compensate their key personnel, including directors, managers, and other executives, for their services even when the company is not generating adequate profits. However, this must be done within the limits prescribed by the Act and based on specific conditions that ensure the remuneration is fair and justifiable given the company's circumstances. The company, while seeking approval for the appointment or remuneration, can fix the remuneration amount or the percentage of profits that it deems appropriate, provided it stays within the limits set by the Companies Act and Schedule V. This offers a measure of flexibility to companies that may be facing financial difficulties, allowing them to continue attracting and retaining key talent even in challenging financial conditions. 2. Factors to be considered in fixing remuneration. While the company has the authority to fix the remuneration within the prescribed limits, it is compelled to consider certain important factors before determining the specific remuneration for its executives. These factors ensure that the remuneration is aligned with the company's financial position and is justifiable based on the experience, qualifications, and other relevant factors concerning the individual. The company is required to have regard to the following considerations. A. Financial position of the company. The financial health of the company is the foremost factor to be considered when fixing remuneration. A company that is facing insufficient profits or is operating at a loss may not be able to afford high levels of remuneration for its executives. Therefore, the financial position of the company serves as a critical determinant in deciding how much remuneration is appropriate, ensuring that the company does not overextend itself financially. It also ensures that the company remains in compliance with its financial obligations, including payment of dividends, operational costs, and other expenses, without jeopardizing its stability. B. Remuneration or commission drawn by the individual in any other capacity. In determining the remuneration of an individual, the company must also take into account any other income that the individual may be receiving from the company in another capacity. For example, if an executive is also receiving a salary for a different role within the same company, such as acting as a consultant or having multiple positions, these additional remunerations must be considered. This prevents the excessive accumulation of benefits or payments by the same individual, ensuring that the overall compensation package remains reasonable. C. Remuneration or commission drawn by the individual from other companies. Additionally, the company must consider any remuneration or commission that the individual concerned may be drawing from other companies. In some cases, key executives may hold positions in multiple companies, and these remuneration packages must be factored into the decision about what is appropriate for the individual's role in the company in question. This ensures a holistic view of the individual's earnings and helps prevent conflicts of interest or excessive pay when considering their overall compensation across different positions. D. Professional qualifications and experience of the individual concerned. The company must also consider the professional qualifications and experience of the individual when fixing remuneration. Highly qualified or experienced professionals may command higher remuneration due to their specialized skills, industry knowledge, and leadership capabilities. For example, if a managing director has decades of experience in the industry, they may be entitled to a higher remuneration than someone with less experience, even in a company that is struggling financially. This ensures that the company can compensate individuals fairly based on the expertise they bring to the organization. E. Other matters as may be prescribed. Finally, the company is required to consider any other matters that may be prescribed by the rules under the Companies Act. These prescribed matters can include various other factors such as the industry norms for compensation, the nature of the business, and any specific regulatory or legal guidelines that may impact the fixation of remuneration in the company's context. These rules help maintain consistency and fairness in the remuneration process and ensure compliance with legal frameworks. For more details, contact us.